Great. Hi, everyone. Welcome. My name's Andrew Apostola, and I'm the CEO of Portable. We're just going to take a few minutes and wait for everyone to arrive, but I'll sort of start to walk through and give some instructions for people, for those that are here. Please use the Q&A panel to post questions for the speakers. Feel free to use it as you think of your questions, and we'll direct the questions to the speakers at the end of the presentation. And also feel free to announce yourself as well. We'd like to hear where you're from and what you're doing and why your interest is, and so that others can know too. You can use the chat window as a space to share your thoughts, comments, have discussions with the community or participants here. And we will be keeping an eye out for questions, comments and requests in both windows. I've got Hayley here as well, who's going to be moderating that conversation, so she'll be helping. If you need any questions, please reach out to her. If you need technical assistance, use the raise hand feature on Zoom, or you can also call Portable. Our number's available on the website. We can help you out there too. I'd also like to let everyone know that this session will be recorded. So if for any reason you do not get to see the full webinar, or you want to share it with your colleagues later on because you found something really interesting that people in your organisation or faculty would like to share, then please look out for it on our website. It's usually available within a few days. It takes a bit to edit it. I'd like to start with an acknowledgement of traditional owners of the land. We are a team, people living and working on the lands of the Wurundjeri and Burrung peoples of the Kulin Nation. We acknowledge their ownership of the land and pay respects to their elders past, present and future. We also acknowledge the rich tradition of oral storytelling by First Peoples, which has allowed for the transfer of knowledge from one generation to the next for millennia. And we'd also like to recognise right now that we're presenting this amidst the context of COVID-19 pandemic and the impact it's having on people here at home and in communities all around the world. A little about Portable. If this is your first Portable talk or interaction, then welcome. We're so pleased to have you. We've been around for the past 15 years. We're a research, design and development agency based in Collingwood. And we use design and technology for positive impact. Work helps people in areas like education, mental health, justice, education, tertiary education in the public sector. And we also work in spaces where it's crucial not only to improve people's experiences, but in many cases provide people in very vulnerable or challenging circumstances the essential services that they need. We're really proud to work in these spaces, and we take these responsibilities very, very seriously. So, I'd like to introduce our special guest speakers, who I can all call friends of Portable. The first, I'm CEO of Portable, and I'm hosting today's session. I introduced Hayley as well earlier, who will be helping in the background with your questions. First off the rank, I'd like to introduce Dan Hunter, who's the Executive Dean of QT Faculty of Law and Chief Investigator, ARC Centre of Excellence for Automated Decision Making in Society. Dan, give us a wave and a hi, just so.
Hey everybody, nice to be here.
Welcome. Next, I'd like to introduce the wonderful Kathy Laster. She's the Director at the Sir Zelman Cohen Centre, Victoria University in Melbourne. Say hi, Kathy.
Hey, hello.
Great. And finally, Gary Cazalet is the Associate Professor at Melbourne Law School at the University of Melbourne.
Hi there, everybody.
Great. So I think the reason why we've brought this, and to give some wider context before we open up the discussion, advances in technology over the past few years have basically been reconfiguring the legal profession, increasingly placing pressure on the higher education sector to rethink, I guess, what a law graduate would look like of the future, and what the general needs of the system are. And I think what we're seeing, and where I think we're all identifying, is this market correction, which is what it is, has really swelled the job queues at Centrelink to just under half, maybe over more of a million people. And many of those people, I'd imagine, are working within law, or are graduates grappling with the question, I guess, what place will I find in the world when this is all over, and is my skill set really going to be relevant? Then we have, in the backdrop, we also have this concept that institutions face the bleak reality of the fact that we've got massive reduction in enrollments, people, rapidly looking at what online learning looks like, and of course people who are less financially equipped to embark on the unknown journey that higher education brings. So it's a whole series of challenges that are facing us, and we thought no better a time to bring together a bunch of extremely smart and articulate experts to have a chat about this. So I'm going to move to and walk you through the three segments. We sort of phase this into a few areas, and we'll spend about 10 to 15 minutes on each before we move into a Q&A. The first is just looking broadly at the higher education correction and what that actually might mean and what faculties are looking at. We'll then move into a section talking about the user experience of law and justice in the new economy, and seeing what that is actually, how people are actually flowing through the system and some of the disruptions we're seeing, some of the adaptations that might be taking place. And then we want to do a bit of future thinking, have a look at what the new technology might hold, what skills and people will be doing in the future. So we'll break it up into those sections, and there'll be questions at the end. But first, to kick it off, I think the first section we want to look at is what's happening in higher education to set the scene. And I think I'd look at what's happening right now in the minute in law faculties. And maybe I'll throw to you, Dan, to sort of kick off about, what are the conversations that are taking place, and what do you see 2021 looking like? Will it actually just snap back, or are we changed forever?
Thanks, Andrew. So I'll try to keep the conversation focused upon law. I'm involved a lot in sort of the wider university strategies around this, and obviously it's very different depending upon the area that you happen to be in. But with law, there are sort of some obvious aspects that I think everyone sort of should be or already is aware of, right? So the first thing is big change in international, which drives a lot of the sort of the research cycle for universities. For the last 15 years, essentially the process has been march your way up the research rankings in order to attract international students, take the money from those international students, reinvest that into the research environment in order to march your way up the research rankings. And the reason that research rankings are the things that people look at is that there's no way really of being able to demonstrate that you're going to have a fantastic experience at any given university. So what that's meant is that universities became addicted to international students, and that's fine. So it's been a great thing, but it's the way in which it's really worked is there's been a sort of a cycle to increase the research output as opposed to the experience of students or the teaching environment or those sorts of things. That particular cycle has stopped really abruptly. It's like the music just stopped, and we're not going to have it in the same way. That's going to disproportionately affect the group of 8, and Gary might have an interesting series of observations around that. But institutions that sort of have played that game are not going to be playing that game in the same way. What that means is that there's going to be much more of a focus upon domestic students, which actually makes it pretty easy in law, right? Like most of our students are domestic. We've got a few internationals, but they typically want to practice here because law is mostly jurisdictionally specific. So what you're probably going to see in the longer term from, over the next 5 years is an increased kind of approach to the outcomes of those students. So graduate employability is going to be important, more of a concierge type of service for the domestic students, so more sort of career support and the like, and a greater emphasis upon the quality of the educational experience. And a lot of that focus will be domestic. The international environment is just changed so much, and it's hard to see it coming back, quickly, or really sort of any time within the normal timeframes that we sort of think of. For law, so that's the sort of the 5-year kind of a thing. There'll be a bit of a change. For law, the shorter time frame is really going to be, I hope, an emphasis that every law school has upon keeping their graduates in education as much as possible. This is not self-serving. This is just, we've seen this happen in the global financial crisis that never really did much for Australia. You know, we were insulated from it. But I was in New York during the global financial crisis, and it hit there really hard. And the graduate outcomes for about 2 or 3 years were essentially zero. You know, there was an entire lost generation of students or graduates who didn't have opportunities because there was just, the market was just in free fall or completely flat. What that meant at the end of that 2 or 3 year cycle was that those graduates were competing for jobs with new grads that were coming out, and the new grads looked bright and shiny and sparkly, and that group who'd graduated in that 3 year period were really lost. They never really bounced back. And so I think what you'll see is a lot of emphasis by law schools and universities more generally to provide graduate opportunities to reskill and retrain their students. And, you know, one of the things, of course, that we're doing at QUT is focusing upon the sorts of skills that we talk about around technology and design thinking and those sorts of things. But that's the way in which I think we're going to see the market operate. Interested in
Gary,
other people's.
Thanks, Dan. Gary, does Melbourne University have a sort of a different posture around this, given the the setting in terms of international students and that similar thinking that Dan's talking about?
I'd love to be able to answer that question, but to be honest, I can't. I mean, I'm not involved in the universities modelling around those kinds of issues. I hear what Dan's got to say about the Group of 8, and but I really can't say. I mean, I know that we've got a large hit. I know that this week that the Vice Chancellor is going to be making some comments about how the university is going to handle the budget. I know that our faculty has also got issues with budgets, like every faculty in every university across Australia. So, and you know, I've seen the figures about the amount of income that we get from international students, but really I can't say how that will necessarily change. I mean, we'll get on to how our teaching has already changed, and I think, you know, one of the matters that you raised, I think, and the title is Rethinking. I would hope that we've already rethought a lot of things already, and it's a continuation of. So the direction that we've been going up to now, all I think it is accelerating that. But we'll get to that, I think, when we get to kind of point 3, I suppose, of the topics that we're talking about.
Dan, I think it's interesting. You're sort of talking about the aftermath of being in New York and that readjustment and seeing students, I guess, that get lost over the past 3 years that's straight out of university having to wait, and also the fact that I think in the States we're looking at a real crisis in law and the money that people are actually paying and for what they're getting. Do you see that? How do you see that playing out with this current time, like in reality?
For the students or for lawyers? I'm not quite sure what you're asking.
Well, I think for law students that are kind of exiting their experience through universities and then becoming looking at jobs and looking at the market and going, well, what skills do I have, and is there actually going to be like, was it correct of me to actually have gone down that course?
Well, I think everyone is going to have that sort of concern. It won't just be law grads, of course, right? Everyone's like, oh, it's a terrible market. I think one of the more interesting aspects about this is, and I know Kathy's got some ideas around this as well. I'm interested to hear her on this, but we've got law degrees are terrible in the way in which they're structured, largely because of accreditation requirements. They don't really focus upon the sorts of skills that you need in order to be able to build a career in law or sort of anywhere else. The Priestley 11 units that are mandated in order to be able to qualify as a lawyer mean that pretty much every law school is constrained in the way in which they teach law, and they don't really teach skills, and they don't teach the sort of the future forward skills that really mean that students or grads will be able to thrive even in this very difficult environment. So what that means, I think, is that grads will have the opportunity to say, all right, well, what was missing in my law school? Hopefully campaign for those law schools to try to change at the margins where they can, but also to start to recognize that they're pretty much going to have to create a different set of skills than the ones that they were taught. Over time, that will mean a change in the way that law school is taught. This may be one of those opportunities for a big reset in our expectations around law school. We've been crying about it for years and saying it's going to happen. It might actually happen this time. It'd be great to think that it would. But I do think that this will shine a really unpleasant light upon some of the failings of the way in which we teach law.
Kathy, what are your thoughts on what
Well, on that, I mean, one of two possibilities, right? The same reason that people do a double degree is to have a competitive advantage. They may not even want law, they may not be particularly interested, but they don't want to waste their high ATAR, and they figure in a tight job market, this gives me a competitive edge. So if the economy is flat, then it may still be that people will then say, well, at least I can show myself to be, which is how employers have typically used the law degree in this period of law school colonialism or imperialism, to say this is a proxy for a smarter person, or at least a person who's got grunt and got staying power because they've done a hard and tough course. So it could have that impact on the domestic market, that people now go, well, I may as well do the double degree now, or I may as well enroll in a law degree because I don't want to go out into the job market. I want to have been seen to be doing something in the meanwhile. So that's the sort of optimistic scenario. The pessimistic scenario is that the relationship between, the cost, the investment in a law degree and the job you can get has got to be demonstrated. And if people are not seeing that, then they're going to find other things. But I'm not sure that there's much of an answer about what will guarantee you a great, interesting, well-paid job. So it's looking at it in the context of what else is happening to other areas or potential vocational areas.
I know that Scott Galloway at NYU recently spoke about the tertiary education and the business model, which centres on professors speaking to a relatively small amount of students being exposed and disrupted by COVID-19 in terms of that relationship. Do you think there's any kind of introspection that universities have to play around that, or even VU itself, Kathy?
So there are various models around, and the contrast is between Harvard and Yale. Harvard has massive classes and has always had that model of one professor, very distinguished, with reams of TAs, tutors, in en masse, and Yale has been handpicked, small, selective. In Australia, some universities have gone to a sort of flipped classroom model. Some have been online for quite a long time, like Deakin. And at various stages, there's this economic push and pull to say, well, it's very expensive to have small groups, so let's go to big ones. And then the students either rebel, or you've got to show a point of difference, or the student experience isn't any good. So often it is a response to a point of difference, and it's a response to student demand. It's interesting. I think students now who are more familiar with being online, there might be pressure for more options online, particularly for people who have to travel or who are older and have got childcare responsibilities. So I think the model will change, but I think the diversity of model will have to remain, because students are not of a piece, and they certainly won't be after this.
If I can add my part, I suppose we have our model at Melbourne Law School is we have relatively small classes. We at least prior to March, I didn't have shoots and lectures model. We had seminar models. So I think our biggest class is about 60, and I might teach in 20s or 30s and so on. But the interesting part of that model is it's very much a relationship model between the teacher and the student, and getting to know the student. The student gets to know the teacher and so on. And that model, I have obviously been, like everybody's been teaching online since late March, and I've been teaching both my subjects. I taught one this morning, I taught one yesterday. One of the questions that we've got, and we're talking about technology in this seminar today, is where does the technology fit in, and where does the kind of human relationship skills fit in, and can technology be used to build those human relationship skills? Because it seems to me that one of the futures of at least somebody with a law degree is less around doing the tech, because the tech will be there to assist, but Dan might have, and Kathy might have other words about this, but also about how to understand other people, how to design solutions like Andrew's organisation does as well, which have the end user, the human, as part of that solution, but also the design of whatever those solutions are. And so how do we teach in an online environment or in a tech environment those kind of human relationship skills around empathy and things like that? I think that's a big question.
If I can, Andrew, I would actually make the point, which isn't often made, that actually we're at a very primitive stage of the technology. We're learning, that Zoom messes with our brain because the images are highly pixelated and there's micro differences between synchronization of voice and face, and your brain is working way too hard to try and make sense of it. So I think that teaching is absolutely relational. We know that. All the research tells us that. But I think as the technology gets better, much better, that will be easier to do as well. But for the minute, face-to-face is always going to be stronger if you're building, teaching and learning on the basis of interaction. And I agree with Gary. That is one of the major things that employers are always interested in. Is this person a good team player? How do they go on with people? What are their soft skills like? They have been brought to the fore. So paradoxically, the age of technology is now weighing interpersonal skills much more highly.
So I might use that as an opportunity to move into our next section, Kathy. Which is around the user experience of law. And I think just if we're looking at the context right now, I think we can we look and see digital sales are said to have allowed retailers to fast forward to a more complete customer experience. Amazon's looking to create the world's first vaccinated supply chain encompassing manufacturers, logistic providers and their actual customers. Telehealth looks like it's here to stay. What does the UX and CX look like for citizens navigating access to justice and the law? And I might start with you for this one, Gary, if you don't mind.
Sure. I think that was I think it was Kathy was going to lead off on that, but I don't mind.
Okay, sure. Kathy, do you want to?
Sure. So the model that the court system and the legal system has been typically historically based on is a wholesale model. Lawyers were the mediators between clients and the professional service delivery through dispute resolution of all kinds. That's become A, unaffordable, and B, I think the demands, the consumer expectations, the digital age is also the consumer age. People now are used to doing their own thing. It's DIY and everything, booking your own airline flights when you can. It's comparative, it's looking for value, it's looking at where's the cheapest way in which I can get this service. So that has presented difficulties for the legal profession. The courts for a long time talked about the problem of the unrepresented litigant. Well, that is now absolutely the new normal, even in the higher courts. So I think what happens is that there's a disconnect in the life world of ordinary people, and I don't want to call them consumers, but they are the sort of the digital age people who are used to accessing stuff quite directly, and this whole other system which has been designed with a highly trained professional mediating what's going on, and they don't need to have any direct knowledge of it. I don't think that's going to able to be sustained. The demands will be different, and I think courts, to be fair, have recognised that. I think it will also depend on the level of dispute. The online dispute resolution pilot at VCAD was very successful, and not only the people who were involved in the pilot, but there was a question that they put on their website to say, if online dispute resolution were available, would you use it? And I think something like 75% of the people said, yes, we would prefer it. So people are prepared to trade off the whole kind of justice experience, and indeed some of the ideology that goes with that, for quick resolution of disputes. So the New South Wales Law and Justice Foundation, for instance, found that something like 95% of civil actions in New South Wales, and has a slightly different system from Victoria, are for sums less than $5,000. So if you think about the infrastructure that goes into, if you wanted to design the most inefficient way of resolving those kinds of disputes, you would set up something like a court system. So I think the horses for courses is going to be really significant, and a great new pressure also coming from government. The other thing is that much of the research says that ordinary people don't distinguish between jurisdictions. That's a technical term. They just go, there's a judge, there's a court, there's a dispute, and someone's going to give me an answer. So all courts are treated in the same way, and they want a one-stop shop. They don't want to understand the intricacies of, you have to go to the higher courts for that. It's an estate matter in the Supreme Court, and, they don't get it. And of course, now they don't have a lawyer to explain it and to make the decision for them. So I think the silos and the competition between jurisdictions will have to end, and they will have to start working together much more, so it becomes a kind of one-stop shop where you don't see the back room of the decisions that you're required to make. Obviously, things like language, which was suited to a wholesale environment, is not suited to direct access by people, and I think that is already changing. The way in which you provide information is already changing, but will increasingly become more user-friendly. So, we haven't now discussed the problem of the vulnerable parts of the community, but as we know, legal aid funding is reducing. So even there, you've seen legal aid provide a lot more support for DIY rather than a lawyer as an intermediary. So there are changes afoot, both for economic reasons, for user demand reasons, for just the shape and nature of the business model of law courts and all kinds of dispute resolution services and transactional services.
Can I jump in just to make one observation just on the back of what Kathy said? Obviously, I think all of those points are absolutely true. But for me, the interesting thing has been how an incredibly conservative profession of law, which has said for years, it's not possible to do online dispute resolution. It's not possible to have courts in this thing. It would require an enormous amount of technology, an enormous amount of rethinking. And then all of a sudden it had to go online, and the courts all of a sudden are doing things by Zoom. And it's just it's a consumer-based technology. It's not specially made for courts. Lawyers are doing the same thing. Gary's teaching his advocacy class on Zoom quite effectively, he says. I know we'll talk a little bit more about that later. And so the old argument of it's just not possible. Man cannot live at that speed, which lawyers and particularly judges have said for years, it's shown to be false. And so now we're moving into a new point where you can say, well, it is possible to do it. Why aren't you doing it? Why are you choosing not to? I had a somewhat similar experience with my version of sort of an old school conservative profession, medicine. And I happened to go to the doctors this morning, and I got on the ferry and I went all the way up the river and then got out and then, went in there, and the person at the front desk said, why didn't you just have a call on Zoom? And I went, I don't know. Well, it just didn't even occur to me, because you got to go to your doctors. And it's just oh, okay. Yeah. Okay. Next time I'll just do it by Zoom. And I think that we've now got that as an option, which wasn't really on the table before.
I think if I can I jump in here as well? I think, there's a discussion about the digital divide that kind of we talk about in the community, but there's also the digital divide in the legal community and the judiciary as well. And so there are those people in the judiciary and in the legal community that are ready to embrace it and have for some time, and are actually really excited. And I know when I've spoken to people that are in the judiciary, at least the ones that I've spoken to, they're really excited. They think, okay, we've been wanting to do this for some time. but we've had people in the profession that are not so happy about it. And now we're just saying, well, we're going to do it. You know, we're going to have case management meetings, and we're going to do them by Zoom or WebEx or team meetings or whatever. I was talking to somebody in the circuit court yesterday, and he's doing things over Microsoft Teams as well, and he's very happy about that kind of experience. But there will be people that are not so happy about it. The advantage for us as academics teaching young people is that hopefully as they leave law school, they will already be in touch with that and being able to use that kind of technology. So I think we're going to see more of it, and people will have to change. In my advocacy class, I had somebody talking from the bar, Victorian Bar, a couple of weeks ago, and she was talking about appearing in cases. And one of the things that the issues that barristers had, certainly in the traditional courtroom, you've got let's say you've got a silk and a junior and a solicitor, and they're all there and they're handing you papers and they're handing you notes and so on. But at the moment in appearances, you might have barristers in 3 different locations, and your instructing solicitor is in another location. And whilst the technology is very good, as a number of people I can see in the chat are saying, there isn't, at least as far as I know, at least the courts are using a technology yet that manages to not recreate the courtroom experience, but at the moment what they're doing is somebody's appearing on the screen to a judge, and if she's appearing, let's say, as a silk, then the only way she gets a note from her instructor is somebody's got a WhatsApp message going on the side, or they use FaceTime, or they're using something else. So there actually isn't an integrated system. But for any tech gurus out there that want to make a lot of money, I think that there's a way of at least establishing some kind of court mechanism where you can have a lot of that private messaging and recreate at least the useful parts of a courtroom environment. And I'm sure there will be more and more of that used.
Do you think we'll be able to retain that though? I think I think it's often that's a conversation about snap back. Like it's easier just to kind of go back and do the same old, to run the same system. And we also know that big tech at court's also a slow and cumbersome process. Do you think that, I don't know, from your experience, Kathy, if we'd be able to retain that feeling, or that sure, okay, we can do, that person is unable to come because they are 4 hours away. Do you think there's been enough of this to change some of those attitudes?
I mean, some of the problem is money. So even if the courts were interested, they would want to have systems where privacy was assured, where Zoom isn't. So there would be resistance to using temporary technology or makeshift stuff on a permanent basis without developing it in ways where people are protected, and the law's got to do that. So I understand the reluctance. I think that the hierarchies are collapsing a little bit, and that will be helpful. So people are now much more reliant on professional staff in courts, and they see that teams work much better. So you used to have a sort of very sharp triangle pyramid, and I think that the technology will facilitate sort of a better discussion about what works and better feedback between front desk people and what's happening in court. So I think courts have been changing, but quietly. They've actually been very bad at telling people that they've changed. So I think they're going to find that they're going to have to justify not providing certain kinds of services and market the possibilities in a much better way to government, but also to people who use the courts.
Yeah, I might use that as a jump into our next section as well. And I will get you, Gary, to jump off on this one, because it's a sort of the question in similar vein. Like, I guess what we're talking about is like is it time for a radical adoption of technology in the justice sector? And will we be able to jump ahead and use it as an enabler, do you think, from what you're seeing?
Yes. Look, it has been used, and it is being used slowly. But I think at one point technology, I mean, I've taught a law and technology subject for a number of years now, and I think that one of the things that people have seen is technology will answer everything. So government really liked it at one point. So if we throw some money towards technology and we do things online and so on, then it'll fix justice and it'll make it cheaper, etc., etc. And in some areas, it absolutely does. And that's great. The other part that we also need to think about, though, is what can it do and what can't it do? So there are aspects that it certainly can't do, and there are areas and people and marginalised people that it may not assist, and there are other areas of law that it doesn't assist. So I think it's worth having a discussion about where technology will work and where it doesn't, what it can do and what it can't do, and then what are the other kinds of skills. And I'm quite conscious from my students' point of view that are learning technology, and I'm sure Kathy and Dan, well, I'm not sure that they'll have this experience, but I wonder if they do, is firms that are employing them, they're employing them for both their technology skills, their understanding of technology, but they're also employing them because they know how to work in groups, they know how to work empathetically with people, they know how to work with clients and ask the right kind of questions and so on. So I think some of those kind of radical changes might be the use of technology, but I think that there's also going to be a change in what kind of skills students need and graduates need into the future. And that, as both Dan and Kathy have said, and I totally agree, the traditional kind of core competencies that are set out in what's called the Priestley 11 for the people that might be listening in that are not in the academic environment, the core subjects that we have to teach for people to get a degree and then get admitted, those core competencies need to change. So that's the radical rethink that I'd like to see.
Dan, would you approach it the same way, or do you think there's an opportunity for a real wholesale rethink of how we're sort of administering justice and applying, using technology to that?
Yeah, the way that you frame it is interesting. That there's an opportunity for a rethink. I don't actually think of it as an opportunity. I think that it will be forced upon us or enforced upon lawyers. So taking the case out or the examples outside of the court system or legal education. If you think about the way that the market for legal services is already changing, has been changing for some time. I think that what you'll find is that the COVID-19 experience really accelerates a lot of those structural changes. So it's going to be harder to open a law firm, a small firm, with the expectation that you're a high street firm. That the writing's been on the wall for those sorts of places for a while, because the sorts of low end legal services that they provide are going to be done by automated systems increasingly, and the reason that there will is there's money on the table at scale to do that kind of thing, and so that's going to drive down the cost of those sort of services, which is a great thing for society, but it's not so great for the lawyers who relied upon divorce proceedings or small scale crim stuff or probate work or conveyancing. So I think that because of the difficulty of operating within a COVID world, we're going to see a winnowing out of a lot of people. You already hear it for some old school lawyers, as you do in every sort of environment. I mean, I sometimes wish that I was 10 years older so I could just take a package and leave. It's bloody hard to work at the moment. And so a lot of people are going, actually, yeah, you know what, I'm just going to, enough already. I'll take early retirement, or I'll just, I won't keep deferring my retirement. And so I think that what we'll see is a real market shift that's driven by this. And then the skills around technology, and around understanding the way in which you can deliver these sorts of services cheaply and at scale is going to be increasingly important. That will be of value to grads with those skills, and they'll be great. It'll be of value to the firms that can keep up and actually manage to find a way of leveraging that kind of stuff. And it will be bad for a lot of other people who just won't be able to find a foothold where previously they would have been able to.
Kathy, is this resonating with you too, or?
Yeah, I mean, I think, the tech stuff is a necessary but not sufficient condition. You've almost got to assume that every graduate from every faculty or college will have to have really high level tech literacy. There's no question about that. And I think it will become easier. So that will be a given. So you have to talk about, well, what's the point of difference of a legal education as against a tech education as against humanities and so on. And I think that for me, there are three things. I was going to say a good legal education, but actually even a bad legal education, for reasons I'll outline, has given a competitive advantage to a law graduate. We have taught them to sift through an awful lot of information. So in a glut age of information, a capacity to really hone down to that one line or one fact that's relevant, that's the nub, is actually a fantastic skill. Now, we've done it by bad pedagogy, but I'm sure there are ways of doing it in a better way. The second is that I know economists are called the dismal science, but actually I think of lawyers as paid pessimists. They are trained as effective risk managers. Everything that a lawyer does is really anticipating all the things that could go wrong. I mean, contract is obviously, you know, the prize example, but you are always on the lookout of what might happen in a negative sense. So in an age where risk is one of the dominant features of the way in which we have to think, risk thinking that we teach through law is very important. But most important, I think, because you might say that there are other disciplines that do that, law provides a way of dealing with relationships between people and people and people and things that is conceptual. And the digital age is absolutely abstract in every possible way. So old law would teach, you know, that there's property and some people have got a lease or a lien or, you know, a license or whatever. And now in the digital age, all of that comes to the fore. That way of thinking about how you create new things and relationships is what law is about, and good legal education will give you. Now, we've always had 50% or more of law graduates don't go into law by choice, and that's a good thing. You know, they're great thinkers and they should be innovators and entrepreneurs and business people and public intellectuals and so on. So I think the question is a legal education good for other things that are necessary in the digital age? And I would argue absolutely. So in your, you know, Decimated or Liberated, I think I'm on the liberated side. And I think law will become much more interesting. The worst part of being a teacher was seeing all these bright young law graduates going to their first jobs and being completely disillusioned, unhappy because the work was boring and it was repetitive and it was grunge stuff. And the business model meant that they just had to get faster at doing the grunge stuff. So I actually think legal education and the sort of work that will be left for lawyers will be far more engaging. And because it will be harder, it will actually still be a great job.
Does that then imply that, and I'll throw to you, Gary, that you know, the digital literacy element is kind of like a core competency for people going forward? Because obviously, if you're relying upon these sort of external, you know, this changed world and technologies that enable does that mean we've got to sort of rethink about, you know, I guess, what that core piece of what you're learning at a law school is?
Yeah, totally. But of course, we could have fun trying to define what we mean by digital literacy, of course. I mean, our students will all be digitally literate, at least at one level, much more than anybody that was there 10 years ago. So they are already going to have that. So then the question is, do they need to be able to program? Yes or no? Do they need to be able to know what, or at least find out what technology they could use to supply a particular solution and so on? And as Kathy said, the technological solutions and the interfaces are going to get easier and easier for people to use. So just like, you know, a number of years ago, I suppose even setting up an internet connection at home, for those who can remember having to do that, that was complex. It's not actually complex now. So a lot of the interfaces, and that'll be part of the user-based design, will become a lot easier for people. The question is, what are those other kinds of skills that we need to be teaching? And for many years, I've been thinking, you know, I know that a number of my students will not want to go out and be lawyers. I'm very happy about that. I want them to go out and do whatever they want to do and be as happy as possible in doing what they're doing and as skillful. And I think we do, as academics, have to think about how does our law school and our law schools create the kind of environment and teach the kinds of skills that the students need to have. The challenge, of course, for academics is to understand what those skills are and to be able to teach them as well. because we can easily teach the skills that we all learned at law school. Well, maybe we can easily, but we can try and teach, you know, contract law and trusts and dispute resolution and all of those. Those are kind of familiar things that lawyers can teach. But the kinds of skills that we're talking about, or a number of us talking about in this session, is skills that could have been, and I don't like this description, but soft skills. So it's those skills that interrelate with the use of technology as well. Technology, in my view, it's an enabler, but it's not the central thing. It won't fix all of the problems. Throw some technology at something and it'll fix it. It won't. So what are those kind of skills that we need to be teaching our students? And do we as academics have the ability to teach them or inspire them? And that's the kind of challenges for all universities, in my view.
I might use that as an opportunity to go into a final thought from everyone before we throw into the Q&A. So, Dan, do you want to build on something there, or?
Look, there's just where to begin. Like, what's the most? These are going to be interesting times. I do think that we will emerge quite different. It's very hard to say what it's going to look like. I can't imagine that the skills that we've been banging on about and the changes that we've been expecting for so long, I suspect that they will speed up, that there will be more acceptance of these requirements, greater emphasis on UX, more technology in teaching in law and so on and so forth. You know, we've been saying this for a long time. So I think that will happen faster, but my experience is always that although I often can sort of get things right, I'm always wrong about the length of time that it's going to take. I always think it's going to happen overnight, and it happens in 10 years' time. And so I'm not really confident that there will be a massive change in the sort of the time frame that we're expecting, although COVID will change a lot.
Kathy?
So I think the disruption will be productive. I think we're going through the process of revolution, which is always tough on everybody. I think that we will need to rethink how we do things, and we will need to rethink the traditional emphasis on hierarchy, and that includes in education. Australia is much more egalitarian, but still there was a sense that the teacher was the one that was sort of imparting. And I think progressively the whole of society is now about co-learning all the time. So as a law teacher, I think I'm really pleased about that development. You know, I once presented a paper on what courts can learn from supermarkets, and I genuinely think that that shift to retail will be enabling of people, and it will force some changes which have been a long time coming. So, you know, it might be my nature. I'm more optimistic, but I don't think it's easy, and I don't think it has been easy. So, you know, I'm hoping that there'll be greater collaboration around the change than there has been as a result of COVID, by the way.
If you're throwing to me next, I feel really positive. I say to my students, it's actually a really exciting time to be law students and almost law graduates. They have lots of potential, they have lots of knowledge, they have lots of energy. The main thing is for the profession and the judiciary to recognise that and not stand in the way all of the time. And I think that the changes of hierarchy that Kathy's talking about in the law school is also changing in the profession. Older members of the profession are realising that actually they don't have the answers. So when I started the profession, the only people that had the answers were people at least 30 years older than me. Now, the recognition is that people 30 years younger than me have actually got the answers, and that's a really good thing. And you know, they're entrepreneurial, they are involved in all sorts of other disciplines as well. So I say to my students, it's a really exciting time, and the possibility of the changes of the online world and the tech coming in will enable them. And you know, I'm sure both Kathy and Dan have got students that are involved in tech areas and entrepreneurial areas outside their law studies. I certainly have. And so I think it's a great opportunity.
Great, fantastic. I'm going to now throw to Hayley and to take a look at some of the questions we've got in the channel
Just a reminder to everyone is that if you do have any questions for the panelists, just put them in the Q&A box rather than the chat box. It's just kind of a little bit easier to kind of be aware of them and see them all rather than missing a couple. We'll start with the first one, which is from Michael. I'm going to throw it to all of you, but I feel like this could be a bit more aimed at Kathy, to be honest. And the question is, what role should the end user, like citizen satisfaction, play in changing or improving court services? From his limited research, Vic Court Services undertakes a range of initiatives to engage citizens, such as the Shepparton Court Building, but he cannot see any that have a specific customer or user end framework that systemizes and embeds the customer kind of into the process a lot more. Sorry, that was a bit wordy.
No, I get it. Yeah, I think that the court system has been used to being a wholesale system. And so it hasn't had to worry about the retailers. That was for the lawyers to go out and explain things. I think that the idea that you would survey customers, which is a very sort of basic level of finding out what they want, is very new to courts. But we have the technologies that banks use, that insurance companies use, that every time you get online on Zoom and asks you how was your experience, that's not built into the court process because they've seen themselves as above all that. The question, would you recommend, say, a criminal matter to a friend? The answer would have to be no. That's the proxy question. So it's very difficult for courts to make that shift because they're either there by compulsion or they're there under trying circumstances. So we do have to tailor it. It can't be quite the consumer model. But I think it's certainly possible. And I think that increasingly courts are finding ways of doing that. I mean, at the centre, we've run some community train the trainer for community leaders from called communities. And that's been, at the county court with the judges involved. So there are programs, but it's not scaled yet. And the Supreme Court has Gertie's Law, which is an attempt to, tell people more about the system and in fact respond to questions that are coming in. So I guess the point is the penny has dropped, but the mechanisms and the sort of scalability of how we build in CX hasn't happened in the court system or in the legal system as easily.
Yeah, great. And this is also written down here. This one's for Kathy, but I think we can open up to everyone. Do you think that this will change other aspects of the legal service delivery rather than just the technologies changing? Will COVID perhaps force legal regulations to rethink the full representation model of service that is in the framework of legal practice regulation?
So do you want someone else to start, or do you want me to start?
You are more than welcome to start.
The short answer is yes. I think, you've got a very robust model now with interdisciplinary practices, and the sorts of work and the biggest employer of lawyers is still the big accounting firms or the big consulting firms. And you've had a shift towards in-house lawyers. So, bits of law are being hived off and lawyers are being active in a variety of combinations. So you've got lots more paralegal work. In fact, in the US, now paralegals are able to do representation. So I think it will actually fracture. Yes, I don't think it'll be full service at all. And actually, it's too expensive to have a lawyer provide full service. The small example of that was in New South Wales. They have a system called LIAC, which we tried to introduce in Victoria's Law at Your Libraries. And it was such a great service that some lawyers would say, first of all, go and see the library, your local library, find out about all of this, and then come and see me. What we seem to do is that lawyers got to do everything and be your one-stop shop. And I don't think people expect that, and I don't think it's the most efficient, and it's certainly not the most cost-effective.
And I make some comments about that, but also more general comments. And it depends a little bit about how long this kind of lockdown goes on, I think. So there'll be some things that will just go back to exactly the way they were. But there are also parts of this change where people are recognising we like doing it this way. We're finding it actually worthwhile. It might be students and it might be clients, for example. So if clients are now getting over Zoom or some other kind of medium advice directly and not having to go into law firms or lawyers, not having to go out to them and getting a different experience that they like, then those changes I think will occur. I think the other changes that will happen, was a kind of a more general question about the practice of law, law firms will change how they practice. Talking to somebody who's a chief administrative officer, I think, of a large law firm, he was saying, they will be changing the way their office spaces work, not just because of COVID. They already have something like 10% of the firm is often working from home or remotely. They think that more people will work from home and remotely by choice, and they will be able to deliver the same services. So the need to move into the CBD and having really enormous flash offices and open plan or whatever they've got in their kind of offices, that will change as well. So I think the practice of law may change. And one of the questions, I think Dan, you were talking about kind of small practitioners and the changes there. I'm wondering, in fact, whether there may be a rise of the ability for people to practice either in small groups or hybrid kind of groups. And I know that we've got at least one participant who's got a law firm that works in that way. I saw her name come up before, where they have people, they come into the office occasionally, but they often work from home. So I wonder if that's one of the changes that will actually occur because people like it if they do.
Can I make one observation that's not COVID related, which I was working on before COVID hit, and don't really have a sort of a view about whether COVID's going to change any of this. If you look at England and America, they're dramatically further advanced in what the Americans called limited licensure approaches than we are. So for in England, the SRA has done a lot of work in opening up slightly different models of limited practice, and they're actually in a process of reviewing that at the moment and potentially expanding the range of people who can do sort of legal work, except for the 6 areas that they've protected. Pretty much all of the Western states in the United States have started to go down this route, which for the longest time was almost completely impossible to imagine. And so you've had very limited sort of approaches for what these called limited licensure technicians or legal technicians in Washington state, but now you're starting to see an expansion of that. There's some really quite remarkable moves that are going on in Utah. Oregon's had some of this for a while. California looks like they're going to do it, and if California goes, then there'll be an enormous change. And that's been against the opposition of the American Bar Association. And so we're starting to see a change in the approach to access to justice over there, where we don't assume that lawyers have to do everything. To picking up on the idea that Kathy was talking about of just getting a lot of information at your local library or using paralegals for a range of things that are not possible. That approach doesn't seem to have taken off in Australia for reasons that I cannot understand. And it will be interesting to see if some of the changes around remote work or the recognition that other people can do this sort of work and don't have to be in Collins Street offices to do it, changes our expectation around that, which will then radically change access to justice here in Australia. But we're not there yet.
Thanks. We'll have time for one more question.
Yeah, I think I'm going to go with Jill's. So how do we account for the voices and experience of those representing in the court system where I continue to observe gender, racism, problematised naivety? These appear to be like long-held kind of views shaping the judgments. So how, I guess, can we work against that, particularly if it does move to a more online system? That is open to anyone. So whoever takes himself off mute first.
Well, thanks, Jill. That's a hard one. That's a really hard one. I mean, the easy answer is wait for the other ones to die out, but that's not really appropriate in any way. But that certainly has changed. I mean, I've noticed some of them. I mean, they have training programs and so on. Actually, I don't even know the answer to that. I am appalled when I see it. I still see it occasionally as well. So I'm not actually sure. I'd like to give you the answer. I could try and give the answer by saying the way we teach as academics hopefully brings out, make sure that students are aware of those kinds of issues and let students know when they're inappropriate in those areas as well. But I'm not sure how we deal with it in the court system. But I'm very I mean, you can have training programs and all sorts of things like that, but some of these issues are so ingrained in people's personalities, that's the real difficulty.
Great, thanks.
That's not a very good answer.
Thanks, Gary. I think I have to be enough for now. I just wanted to thank everyone, particularly Gary Cazalet, Dan Hunter, Kathy Lester, for your time and your wisdom over the past hour. I really appreciate it. If you don't know these guys, you should go out and look them up, their various institutions, and I'm sure they'd be happy to reach out to you and hear from you on LinkedIn. If you're interested in this kind of topic around justice, we had another presentation that was on a few weeks ago, and so you can find it on Portable's website, events system. You can see the full webinar as well. And also, we've got a whole range of reports. So we released a report last year into Design for Education. We also have Design for Justice. So if you're interested in areas of justice or design and where they meet in education, then please feel free to download and ask questions. But thank you again for your time, and I look forward to seeing you all at the next event.
Bye.